Shall we make a start?
Yep, let's do it.
All right. Good afternoon, everyone, and thank you for joining us this afternoon. For those of you who don't know me, I'm Raynia Theodore. I'm a principal in the Corporate Advisory and Franchising team, and I'll be your host this afternoon. Before we begin, it's probably for those who are new to MST, I'll give you a quick rundown on who we are. We're a full-service commercial firm with a private clients arm. We've acted for Australian and international businesses and private clients for more than 65 years across corporate, commercial law, employment, property, dispute resolution, litigation, wills and estates, family law, and of course, franchising. Having looked at the attendee list quickly before this, I see we have a mix of people on this webinar: business owners, directors, accountants, and other advisors who support those businesses. So whether you're making decisions on behalf of a business or helping clients make them, hopefully today's session will give you some practical guidance of some current issues businesses are facing in 2026. Before we formally start, just a couple of quick housekeeping points. We are recording today, so if you prefer to be off camera, feel free to turn your cameras off. Also, we ask that you keep your microphones muted, of course, not the presenters. Questions. We are hopeful we'll have questions at the end. So what we suggest you do is pop your questions in the Zoom function at the bottom of your screen on the way through so you don't forget them. Okay, so we have got a lot to get through this afternoon. We're in summary, looking at legal issues that sit quietly in the background for years, but become important as a business grows, changes direction, ends up in a dispute, or prepares from a sale. What we're going to do, you're going to hear from 5 principles of MST. I'll be kicking off with business structures, contracts, protecting business value, particularly where businesses have had documents in place for many years, and asking the question or posing the question about whether they still support your business today. Louise will follow me and talk about another key asset of a business, and that's the brand, including taking you through trademark ownership, the use of IP, and third-party content. Evelyn Marcou will cover property and leasing issues and how a lease can affect a business's ability to expand, relocate, restructure, or sell. Skermer will look at commercial disputes, including what businesses can do to avoid them or minimise the risks of disputes or disagreements. And James Sanders will close us off with a workplace law update and some employment issues that everybody should be thinking about in 2026. Each area of law is very, very different, but they rarely operate in isolation. So a decision that the business makes in one area can have consequences for another area pretty quickly. In terms of structure, we've divided today's session into 2 parts. In the first part, we'll each focus on issues we're currently seeing in our respective practice areas, and then we'll explain what risks we are seeing and give you some practical tips or guidance to take back to your businesses. In the second part, and hopefully the fun part, we'll bring all 5 areas together with an interesting case study. It's based on a real matter that we were all involved in. Obviously, we're changing the names and some of the details. So in terms of, I'll kick off now with my portion, which is what businesses should be considering in 2026 from a corporate point of view. So what I see is most structures and legal documents were put in place when a business was really in its infancy. It started off. However, businesses have grown, new owners come in, new employees, customers, you may even change your product range and service range, and risks basically come into play if the structure and documents don't keep pace with the changes you're making. The question is not really one about whether you've got contracts in place, it's whether your structure and your contracts still reflect the business as it continues to grow and as it operates today. So what I feel and am seeing in my practice is the 5 things that businesses should have at top of mind in 2026 are things, well, starting with firstly the business structure itself. What worked in the beginning may not be the appropriate structure for the business today. The second thing I think is important to look at is the governing documents. So whether it's a partnership agreement, a unit holder agreement, a shareholder agreement, I see a range of issues from having no agreement in place to agreements drafted at the outset where the business was very different and the people were very different, and then they're forgotten about. I'll then go through some, contracts, supply contracts, customer terms and conditions. Again, written years ago, do they suit the business as it is today? The issues I often see here are, again, old terms and conditions that suited a business some time ago, haven't kept pace with legal updates. I often see, or clients tell me, the original document was downloaded from the internet or drafted by, or what we're seeing now is drafted by AI. Again, is it appropriate for the business? Also, finally, leases. Evelyn will take you through those documents. All of these documents are important, but unfortunately rarely feel like a priority when everything is going well. The old, if it ain't broken, let's not fix it. So to give you a bit more context to those specific areas, I'll start off with business structure, as every business should probably start with. The hottest topic in 2026 that I'm seeing in my practice is the proposed tax changes that were announced earlier this year. The key change that's probably attracted the most attention in this space is the 30% minimum tax that will apply to taxable income of discretionary trusts from 1 July 2028. I've been fielding lots of queries about this, and I don't profess to be a financial advisor or tax lawyer, but we do know that, or we're basically in fear that the old family discretionary trust and the good old bucket company may be a vehicle of the past. If changes are required in this space, establishing new structures, seeking financial advice, refinancing, all of this takes time and costs money. So the best advice I can give you at this stage, given we don't have the full detail, is keep communicating with your legal and financial advisors and stay on top of these changes, because restructuring may be needed. Other things I see from poor structuring, probably the best way for me to illustrate this is to give you some more stories. So I acted for a franchise network a few years back, had all its assets in one company, including all its IP, important trademarks, franchise agreements, leases. It ended up in a huge dispute and arbitration with an overseas master franchisee, which saw the franchisor being sued by that master franchisee. It lost that arbitration. It ended up being wound up and the network being sold. Lesson to be learned from that one is, had the international business and even the IP been in a separate legal entity, the Australian operations may have been able to have been saved. Another war story, another favourite, a retail client with 45 retail stores, all in different companies. This complex structure was devised years earlier and made pre-sale due diligence an absolute nightmare. It ended up a really long sale process, expensive and difficult to manage. So structuring is an important factor to take into account. It should be planned in the first place, but it should evolve as your business evolves. Moving on to the governing documents. The time to build your exit strategy, believe it or not, is before anyone wants to leave, and right at the beginning. The way we see shareholders agreements, unit holders agreement, whatever that structure may be, is it's a bit of a corporate prenup. They need to explain the roles, how decisions are made, what happens if owners can't agree, is there a workable process if someone wants to leave, how you value that someone's interest. We're often involved in oppression claims and even a just and equitable winding up, which that's the legal term. What it pretty much means is it's the corporate equivalent of a divorce without a prenup. So having good documents that evolve with your business is really important. Supply contracts, I mentioned that earlier, they really should be in writing. never ceases to amaze me how many clients have handshake arrangements. And I'm talking some of the sizable clients as well, big or small. Remember, a handshake offers very little protection when a supplier's factory burns down or they go bust or there's a global crisis. I also see, unfortunately, unwritten or outdated arrangements which leave you equally exposed. The other day, I was speaking to a client who said, I was asked to sign this contract and I simply accepted its terms because it was a bit of a David and Goliath situation. I felt I had no choice. Again, contracts should reflect your business and your needs. Get advice. Not everything is not negotiable. Customer contracts. These are the old good, T's and C's. Template consumer and small business contracts should now be checked for unfair contract terms. The regulator, which is the ACCC, has made it clear that their enforcement priorities include looking for unfair contract terms. Unfortunately, what I see in my practice is that these laws aren't being taken seriously. What everyone in the room should understand is the mere presence of such clauses is actually unlawful. And since 2023, November 23, they should be taken seriously because significant penalties apply. The penalties are the greater of $100 million, 3 times the benefit derived, or 30% of adjusted turnover. So getting this wrong will make legal fees associated with an unfair contract term review seem cheap or will pale in comparison. Also have a think about payment and security arrangements. These are critical in an economic climate where customers are taking very long time to pay, and we're seeing record numbers of insolvency. You may think you're protected because you've got a retention of title clause in your contract, but that does little other than say you've got title. It'll probably be worthless if you haven't protected your interest by registering on the Personal Property and Securities Register. So what should businesses do? You don't have to rewrite your contract every year, but you pretty much should identify what contracts you have in place, how old they are, and have a real good look at those contracts because they basically form the legal foundations for your business. Where we often see it come to a head is when someone wants to sell their business, and then it's a mad scramble to get all these documents in place. Are key agreements signed and able to be found? Can they be transferred easily to the buyer? Does the business own the really important assets? In terms of what I see usually as part of a sale process is due diligence exposes significant gaps which end up costing or ending up with a reduction or negotiation for a reduction of purchase price, and I've even seen a deal be killed as a result of things that have come out of due diligence. To give you some real life examples, buyers, lawyers have identified things like a missed wage rate increase, cost one buyer or one vendor or client $200,000 in purchase price. Key customer contracts with change of control clauses, letting customers walk away if there's a sale of the business. And then even contracts that say that, can't assign the software or the IP license. All of these are examples, real life examples of where we've ended up in a renegotiation and a significant reduction in the purchase price. So key message I can give you is probably get your house in order well before issues arise and well before a buyer comes knocking at your door. In terms of a key asset, as I said at the outset, brand is one of the most important assets of a business, and I will now hand over to Louise to take you through some of the issues we're seeing in 2026. You're on mute, Lou.
Unmute. Okay, can you hear me now?
Yes.
Great, thank you. Okay. All right, so your brand is basically your identity in the marketplace. It's what tells customers they can trust you, what sets you apart from your competitors, and what carries the value of everything you've built, from your reputation to your prices to your customer loyalty. If you don't protect it, you risk someone else cashing in on your hard work, customers getting confused or misled, and your ability to grow or expand into new markets being blocked because someone else got there first. It's less about chasing down every infringer and more about safeguarding the thing that your whole business is built on. The key point is that using a name is not the same as legally protecting your brand. So, next slide, please, Dina. Thank you. Protecting your brand and reputation is bigger than just registering a name or a logo. Brand includes trademarks such as your business name, product names, logos, and other signs that identify your business. It can include creative assets such as website content, photographs, campaigns, templates, and designs. And it can include confidential information, customer data, pricing information, things that competitors would be pretty interested in. More than 97,000 trademark applications were filed in Australia last year. So people are trying to do the right thing. But even so, the risk is that legal protection is not put in place early enough. A name launched, a website is built, and a campaign goes live. But have you stopped to check whether your business can legally use, own, and protect what it has created? I'll now take you through 3 gaps that I see in practice. The first gap is usually the name. A business may have registered a company name, a business name, or a domain name, and they may assume that that means they own the brand, but it doesn't. We have had clients who've operated for years without the protection of a registered trademark. If you don't have your marks registered, it's not fatal, but it means that you may need to provide evidence to prove when your rights to the mark started, rather than being able to just simply show your trademark registration. One client of ours had operated for 20 years without a registered mark. Trying to register the client's marks after so long was actually really difficult. There were many marks with similar names that had been registered since our client started their business. So when we came in after that, we had to try and prove that our client existed in the marketplace before every single one of them. But that wasn't as easy as you'd think. Lots of evidence had been lost over the 20 years. A computer system change meant that photos and other evidence had just disappeared. So no registration is a serious gap. Another gap is where there's, I want to just explain that a slight change in spelling is not enough to avoid a claim of trademark infringement. One thing to be aware of is that ASIC and IP Australia don't talk to each other. ASIC will allow you to register a company name or a business name that is only slightly different from an existing company name or business name. However, the register of a company name, business name, or domain name will not give you a monopoly in the same way that to the mark in the same way that a trademark will. To illustrate some broader issues that arise in this space, I want to talk about the bed, bath and table example shown here in the slide. Bed, Bath and Table sued House, Bed and Bath for trademark infringement and also for misleading and deceptive conduct. The case went all the way to the High Court, which found that there was no trademark infringement because the word house was seen as being distinctive enough. However, the court found that there was misleading and deceptive conduct. So before investing in building a brand, including signage, packaging, a website, or a campaign, businesses should seek holistic advice by conducting trademark searches and also considering whether your get-up and messaging are sufficiently different from an existing business so that risks of misleading and deceptive conduct allegations can be avoided. And I'll revisit this in the case study. Okay. All right. So the second gap is that assuming the job is finished once the trademark registration is complete, but that's not the case. Classifications and classes need to match the way the business actually operates. Over time, goods and services that you provide might change, and it's really important to check that the class of goods and services is still up to date. You can't just add new goods and services to a registered trademark. You need to start again. Having the wrong entity listed as a registered owner is a really massive gap. An application must be filed in the name of the first user or controller. A mistake at the outset will make the registration defective, and it can't be rectified by assigning the trademark later. That, of course, doesn't mean that you cannot protect your IP by having it owned in one entity and licensed to another for asset protection purposes. But the key is that the owner needs to exercise control over how licensees use their marks. Seems elementary to say, but keeping track of your trademarks is also equally important. Sometimes when we come to renew a trademark, we find that the owning entity has been deregistered by ASIC because the owners have forgotten which company legally owns the trademarks. And that's a massive problem because it's very difficult to get a trademark out of ASIC because they vest in ASIC. So the next dot point and common gap is assuming that honest and concurrent use will excuse prior knowledge of an existing mark. In Zip Co and First Mac, the company called First Mac had an earlier registration for Zip in relation to financial services. So Zip filed an application and found out about First Mac's application when they received an adverse trademark report from IP Australia, but they ignored it and then launched their buy now, pay later service under the Zip brand. When it went to court, Zip sought to rely on the defence of honest and concurrent use, but the High Court disagreed, stating that actual knowledge weighed heavily against a finding of honesty. In trademarks, keeping evidence of use is really important. If you haven't used your trademark in relation to each of the goods and services mentioned as part of your registered mark for more than 3 years, you risk an application for cancellation for non-use. So the message is use it and take pictures, or maybe you'll lose it. So the third gap I wanted to talk about is ownership. Businesses are creating more material using third parties or AI tools, and this is where ownership disputes can arise. For example, an agency may design a logo, write website content, or produce a campaign. Unless the agreement between the agent and the owner clearly deals with ownership, the business may only have permission to use that material rather than full ownership of it. Then AI adds another layer. A business might use AI to generate a name or an image or a campaign without checking whether the output is too close to an existing trademark or someone else's content, because, as we know, AI tends to copy what it knows. There are currently no reported Australian court cases dealing with copyright claims over AI-generated or AI-trained material, but the copyright laws require that a human author is involved in the creation of a work before it can be said to be copyrighted by that person. There is also a confidentiality risk. Staff may enter customer information, internal documents, or commercially sensitive information into an AI platform without considering where that information goes or how it may be used. So the practical question is, can the business show a clear path from the person or platform that created the material through to the business owning and controlling it? Be aware that the business might not legally own the AI creation. The gap often surfaces during a sale, an investment process, a dispute, or after the departure of a key person. So what to do now? There are 3 practical things that businesses can do. The first is to get clearance. Before launching a new name, product, or campaign or piece of content, engage a professional to conduct comprehensive searches of the market and check whether it's safe to use. And do that before spending a lot of money on branding, packaging, and advertising. The second is get control. Register important trademarks in the correct entity and make sure agreements with employees, contractors, agencies clearly deal with ownership, confidentiality, and the right to use the material. Also keep records showing how the brand is being used and who has authority to use it, and update those records regularly. The third is to monitor. Watch out for similar names, misuse online, and changes within the business. A registration that suited the business 3 years ago may no longer cover what the business does today. The main message is that registration alone does not answer every question. Ownership, use, control all matter, and work together to protect your brand and reputation. Your brand may be one of the most valuable assets in the business. So the question is whether you can prove that you own it, control it, and that you can stop someone else from taking advantage of it. So that's it for me for now. I will hand over to Evelyn Marcou, who is going to talk about another key asset, which is your premises lease.
Hi all, thank you, Lou. So today I'm going to talk about leasing in general, but also some things that we're seeing creeping up in the market at the moment. One of the things that always has astounded me is when businesses setting up from the very beginning, they think the lease is just a small part of what they're doing, as in that's there to run their business from or to store their goods at. They're not putting enough thought into what a lease is, how important that lease is as part of your asset, and what you might want to think about from the very beginning that might help you throughout your business, the life of the business. A lease may look like a fairly standard document, but it can have a real impact on what a business can and cannot do. And the problem is that these all stay in the background until you get to the point where you, for example, might want to expand or sell or downsize. Before I go into some of the issues that businesses face with leases, I just want to talk about a few things that are happening in the market at the moment, which probably everyone here is probably aware of. Amid the rising economic pressure at the moment, we're seeing a lot of tenants challenge outgoings. They're really scrutinising what they're paying, their total occupancy costs, rent. They're looking at, for example, insurance. Insurance costs have risen dramatically. People are now looking at, okay, well, is the landlord actually over-insuring? Is the landlord insuring things they're not allowed to insure for under the lease, that I'm paying for all these costs? And, increase in obviously other outgoings is causing some, financial grief for some tenants as well. Now, the big major ticket item, and I'm sure you're all aware of this, is our lovely government and the land tax, the increasing land tax costs, and where those who are not retail tenants are actually paying for the cost of land tax. VCAT is currently inundated with claims by tenants that they are a retail lease. Now, this topic of what is a retail lease troubles us as practitioners. So for the rest of you who are not property lawyers, I can't even imagine what your thoughts are about, what is and what is not a retail lease. Sometimes it's pretty straightforward. Other times it's not. And a lot of the decisions coming out of VCAT are really complicating the determination of what is a retail lease, and also really broadening the definition of what is a retail lease. And a lot of these cases are actually, the tenants are being successful. They're successfully arguing that even though their lease says they're not retail, it's prohibited, they are in fact retail. And what's driving all these applications is the fact that land tax has become such a big ticket item and such a big expense for tenants and for businesses. Another real issue we've got, and this happened to me a few weeks ago with one of my poor clients, okay, the land tax is a certain amount, you factor that into your budget. The landlord goes ahead and sells the freehold to a foreign investor, and all of a sudden the land tax has doubled and become quite, expensive. In this particular case, it was double the cost of my client's rent, which you can imagine was not a great outcome. And it come down again to the definition of what could be passed off by way of land tax, whether the foreign surcharge could also be passed off or not to the tenant. So that's it's been a big ticket item for a couple of years now, but land tax in particular is really dominating what's happening at VCAT at the moment. And the other sad thing is there are a lot of tenants who are under such financial distress that they are defaulting in payments of their rent. They're behind, they can't afford to pay rent and outgoings and run their business, and they're looking to get out of their lease. And this also then makes landlords look at things like, okay, well, what kind of security do we have? Do we have personal guarantees? Do we have an updated bank guarantee? So it's really determining what's happening in the marketplace between landlords and tenants. And, people are feeling the pinch at the moment. And obviously, people trying to get their total occupancy costs down. Businesses are trying to get them down so they can make more profit. And the other thing is, obviously, people are also looking at if they can't afford to stay where they are, can they relocate? Can they assign their lease? That leads into the next slide, is how often does this play out and how does this play out? So a lot of business tend to make decisions without actually looking at their lease until the very end of all these decisions being made. So they're so quick to say, well, okay, this is what we want to do. We're going to rebrand, we're going to sell, we're going to expand, we're going to, you know, assign our lease, we're going to do all these sorts of things, but they're not looking properly at their documentation. Sometimes they're looking at them a little bit too late in the piece. Everyone's so busy working out, okay, we can sell our business for this amount of money, but haven't actually had a look at their lease to say, well, hang on, can I sell it? Whose consent do I need? What's the process in my lease? You know, and also things like the permitted use clause, you know, that becomes really important, what your lease says your permitted use is when you're trying to sell your business and or just get out of your lease or assign your lease, because pretty much in every jurisdiction, it's a kind of blanket no for a landlord if you try to sell your lease and change the permitted use. That gives a landlord a ground to say, we don't consent. So it's really important that you're looking at these things from the early, you know, the early stages of when you're making these decisions about what to do. It's also important because, again, from the very beginning, you think everything's going to go, you know, swimmingly well, and I hope for all you business owners it does. However, things like tenure become really important, as in your lease term and your, you know, your further terms, because you've probably all experienced this, but when you go to transfer a business and sell your business, the buyer and their financiers require a certain amount of tenure, so they know that if they're, for example, lending money, that they're going to be able to recover that money because the business has got enough time to make profit. So things like your terms, and it's a really hard balancing act, because whilst trying to get the tenure for the future, you also don't want to lock yourself into long-term leases, because then you're stuck potentially for 7 years, say, and that might not suit your business needs if you wish to expand and grow, or you need to downsize because you find the space is too big. So it's a balancing act, that's for sure, and there are competing interests there, but you've got to try and find that balancing act. Most importantly, you know, when you are going to sell or make a decision or expand, look at your lease, look what it says, look at the consent process. In Victoria, for example, from the time you write to your landlord and seek their consent, they've got 28 days. It's a long time. So if you're going to them a week before settlement, unless you've got a very sympathetic lawyer on the other side or landlord, they're not going to rush for you, because you've left these things to the last minute. So make sure you're actually considering all these issues. That position can even be more complicated when you're trying to sell a larger network. So you've got multiple sites across multiple jurisdictions. Every jurisdiction has its own laws, its own process, and every lease will be different. I guarantee you. I read, sadly, thousands and thousands of leases, and they are all different. So the process in there is different for each landlord. So you really need to make that a priority and look at it. Which goes to my next slide, is, you know, when will the lease that you've entered into from the very beginning support your next move? Now, none of us have a crystal ball, but there are a lot of things that you can do as a business owner to assist you in the future. Things like getting a condition report, things which will, for example, document the condition of the premises, because when it comes time to sell your business and transfer the lease, your new owner is taking on the responsibility of make good. Your new owner is going to want to say to you, oh, do you have evidence as to what, you know, the premises were like at the start? Do you have to remove the whole fit out? All of these things, make good is the biggest expense when it comes time to exiting a business. So it's important that your lease provisions are sufficient enough to document your exit as well as a sale of business, not just when you're coming into the business. You know, permitted use. I see so many narrow permitted uses. You really want to try and get your permitted use as broad as possible. Again, it's kind of a balancing act. For example, if you're a cafe, you don't want it to be a cafe selling coffee. you want to be maybe a restaurant. So then when it comes time to assign your lease, it doesn't have to be to a coffee shop. It could be to a food, KFC, for example, or whoever. My point being, you've got to really think about these things from the very beginning. You've got to look at your terms, 5-year leases with no extra terms is not really attractive to anyone when it comes time to selling your business, especially if you're halfway through the term. Rent review clauses, all of that's really important, and all of these things should factor in your decision from the very beginning when you're entering into that lease. Don't wait. And things like also, knowing when you have to exercise your option for the further terms, especially if you're a non-retail tenant, because when you're a retail tenant, the landlord's got to give you a notice. When you're a non-retail tenant, the obligation's on you to make sure you actually do exercise the option within the windows. Now, we've had a lot of landlords use that against tenants when they want them out, where they haven't exercised the option, the onus has been on the tenant. You might lose your right to be in those premises. So be very careful, make sure you're on top of these things. An early review of your lease can cause you, so much less pain when it comes time to selling a business or transferring a business or downsizing. So I know it's not a sell for lawyers. I'm just saying it's really important that you do get that lease looked at from the very inception. So I will now hand over to Mark, who's going to talk about when things do go wrong, how do we handle those commercial disputes?
Thank you for that, Evelyn, and hello, everyone. My name's Mark Skermer. I'm the head of litigation and disputes here at the firm. And Evelyn's exactly right. At MST, we handle the front end in terms of contract, lease, IP, and so forth, but we also handle the back end, which is often disputes, whether that is a commercial dispute or an actual litigation. So I'm going to be talking about that today. I'm going to talk about my own experience over the course of the last 18 months. And the theme that I'll try and capture today from a disputes perspective is a fairly simple one. Decisions and actions taken early can often have a positive impact in terms of what can happen later. So be aware of risk, be mindful of available evidence, and get evidence early. Slide, please. What we're seeing in the market, I'll talk briefly about a couple of trends I've seen in the market, some of which will be well known to you. Firstly, commercial relationships are under greater pressure. Not a surprise by any means. Businesses are dealing with higher production costs. Customers may not be paying. Projects might be delayed. There might be issues with the performance of those projects. This can often create the cauldron from which a dispute or a litigation arises. Secondly, rights are being enforced more aggressively. Evelyn was talking about leasing matters, so I might take a cue from her and talk about that. In a leasing context, some people might serve breach notices quickly. They might seek to action a termination quickly if you're a landlord, as opposed to letting it ride and see what happens over 3 to 6 months, where a position can get demonstrably worse. So we're seeing parties act more quickly than perhaps what they have in the past. And within a dispute, they can progress from 0 to 100 fairly quickly as well. But not only that, we've had a lot of queries in terms of asking questions about the continuity of a relationship at all. So talking about franchising, which has come up previously. I've seen an upswing in people approaching us, speaking for franchisees, for example, and asking whether there are facts or circumstances that will allow them to get out of an agreement or alternatively renegotiate agreement. Now, sometimes that's possible, but more often than not, it's not. And it becomes a bit of a Hail Mary play. And it's sort of reflective of people's approach at the moment in terms of pressures and issues they might be dealing with. Fourthly, payment pressure and insolvency continues to create real tension. This is particularly relevant in the building industry, where insolvencies continue to remain very high, whether it's defaults, unfinished work, or in some cases, insolvency remain as key issues. And can I also say, and I know there's a few liquidators here today, can I also say there's two ends of the stick here, isn't it? There's the performance of the contract, but there's also then potentially dealing with preference payment claims and related claims if a company does go into liquidation. So it's a full gamut of issues, often in a fairly short time frame, which can be tricky. Finally, let me say, and this is not a bugbear, although you're free to treat it as such. Finally, we're across the board at MST, we're seeing people approach us and they are dealing more directly with the matter themselves. So speaking on my own behalf, I've seen a massive upswing in the last 2 months, for example, in relation to people that have started a proceeding. They've begun the process. They've started putting some expert evidence together. They might have even drawn some submissions. More often than not, they receive that false sense of security through AI. Oh yeah, AI will tell me what to do, no problemo. But they realise, 6, 7 weeks out from a trial, hang on a second, AI is not going to be sitting next to me in a courtroom. I'm the poor person that's going to have to speak to this, and crikey, I don't know what I'm doing. So we've seen certainly I've seen an increase in those types of queries, and that's difficult because from my perspective, sometimes I have to try and unbake the cake. It's almost ready to come out of the oven, but the matter needs to be unwound, whether it's expert evidence, whether it's pleadings, whether it's getting some submissions together. So that's something that's really come about recently, which has been interesting. Slide, please. Nice. Ladies and gents, you can see two handsome devils there. The one on the right is certainly more so. Here's a slide where there's a couple of points in relation to how it plays out in a commercial context. A lot of that is de rigueur for most of you, so I won't go through it in a lot of detail. Safe to say that contract disputes, whether it's franchising, a lease, a commercial dispute, they take on a life of their own. Acting quickly to try and deal with them is going to be of benefit. Otherwise, issues can arise, whether it comes out of delay, whether it comes out of lost opportunities, which is often an issue we bump into in litigation. So, yeah, just be mindful of those, please. Slide. Thank you, Dana. I thought I would end today by talking a bit about what you've got to do now or things you need to be thinking about now. And this is sort of directly informed by my own sort of recent experiences. Firstly, risk identification. Whether a matter has been kicked to MST or whether you are handling it yourself, just be aware of risk. What are you communicating to another party? What are you putting in writing? What are some of our own issues? For example, are you relying on some employees who are maybe communicating things or not behaving diligently in terms of managing your own evidence profile? Just be aware that risk identification is important. If you've got a mind towards it, life may be easier down the track if something becomes a dispute. The second thing I want to say is about evidence retention. It's critical. Can I say on that topic that in the last 12 months, I've run 3 trials. 2 of those trials, the key witness has been a former employee. That is really tricky for us as litigators and you as business owners and business participants, because at the end of the day, the case relies on someone who's no longer here, no longer has that sense of loyalty, no longer has that sense of belonging. Now, if they've left on good terms, fantastic, but sometimes they don't go on great terms. So 2 points to make. Firstly, retention of information. If they have a phone, keep it. You may need it. Record things like emails, memoranda, internal things that have happened, the jobs that they have done. Try and keep good records. You may need them. Secondly, to the extent you can, try and manage those relationships. Now, it's not always easy when an employee goes out the door, and James will be talking about employment law in a moment, but from the perspective of keeping people on side, especially if you know there's a big dispute coming down the line, can be really important. Thirdly, get a health check. We, all of us on this webinar are available to you. If you want to have a chat to determine where you're at, what's going on, you're very welcome to do so. We might be able to identify a risk you hadn't thought about. We might be able to nominate a strategy that might be of great benefit to you. So if you're in the infancy stages of handling a dispute, by all means, get in touch. Always happy to have a chat. Finally, never lose sight of the commercial objective. That can mean many things to different people. It might mean preserving a relationship. It might mean recovering some money. It might mean setting a precedent so other people know what you stand for in the industry. Run disputes according to that mindset. Keep the commercial objective front of mind, and that can often be a North Star, if you like, in terms of where it goes and the steps you take to get there. I should say that MST can help. I'm very pleased to announce that Michael King has recently joined us, a very capable special counsel in the litigation team, and he and I as a collective are able to assess strategy. We can advise on risk. We can implement that strategy with a view to then getting the best outcomes available to you. Now, as we all know, litigation is a two-way street. It's a contest, but often the strategy steps and the particular decisions made during the course of the process put Michael and I in a much better position to get you a better outcome down the track. And that really is what we're interested in. So my central message today is that early decisions do matter. Please identify the risk, preserve the evidence, obtain advice, and remain focused on the commercial objective you're trying to achieve. I'm very grateful for your listening today, and I'm now going to hand over to James, who's going to talk about employment matters. Thank you.
Thank you very much, Mark. Good afternoon, everyone. I'm James Sanders. I'm one of the employment law partners here at MST. I'm going to finish the first part of this seminar today talking about employment law issues that you need to be looking at for the remainder of 2026 and into 2027. There are 5 areas that I believe you need to be paying particular attention to for the remainder of this year. The first you should already be up to date with, Payday Super. That came in on the 1st of July. You were required to start paying superannuation every pay cycle, not every quarter. This opens you up to more breaches if you don't do it in time, which leads to further penalties, so it needs to be focused on. The second is that every state and territory now has statutory right and obligations for psychosocial hazards. This means that you now have to focus on the mental health of your employees as much as you do on their physical health. Everyone is attuned to making sure there's no tripping hazards, but not as many people are attuned to what is going on inside their employees' heads in terms of workload and risks in the workplace. Third, the ever-present worker classification. Employees and contractors alike are looking for more money. It's tough out there at the moment. And so they want to stay as contractors or casuals for a longer period of time. But that opens up risk for you as the employer for misclassification and leading to underpayments or non-payment of superannuation. But with that said, I think there are 2 very key areas you need to be thinking about. The first is flexible work arrangements and more specifically, working from home. Since the introduction of the Fair Work Act, employees have always, or certain employees have had the right to request an ability to work from home. It wasn't until 2023 that this was changed to provide employees an ability to appeal any decision of the employer. Prior to that, employers were free to reject the requests on any grounds they saw fit with no fear of reprisal. Now, you as an employer need to go through a true process of ensuring that employees, or when an employee makes a request, you've considered the refusal before making the decision. And whilst we've had some decisions go both ways from the Fair Work Commission, now that they are making their way through the Commission, there is a very clear trend that the Commission is providing to us. And that is, if you as the employer have not truly considered the employee's request, and you haven't considered how the refusal will affect the employee or what the effect will have on other employees or your business, the Commission is going to find in favour of the employee, including allowing them to work from home 5 days per week, even if the reason they need to work from home is that they've decided to move 2 hours out of town and away from the office. However, if you as a business have genuinely attempted to resolve the issue or the request with the employee before refusing by making alternative options available to them, identifying to them the reasons why requested flexibility isn't going to work, the Fair Work Commission is making very favourable decisions for employers. And so it comes down to the important fact of what have you considered before you make your decision. This is only going to be exacerbated in Victoria. We've currently got the draft work from home legislation before the Parliament. We expect that to be in place before the start date for large employers of 1 September. And you will now have to make a decision, not only employees requesting under the Fair Work Act, but your Victorian employees making a request or accessing their right to work from home 2 days a week. So it is more important than ever to ensure that to defend any of these claims, if you decide to refuse and they are appealed, that you have a paper trail. Make sure you've gone through the process correctly and documented exactly what you've done to make sure you give your best chance of asking employees to, or requiring employees to return or stay at the workplace. Essentially, if it's not in writing, those conversations never happened. The second key issue you need to be thinking about is an increased chance of litigation. The the president of the Fair Work Commission presented at a CPD earlier this year, where he indicated that we were expecting 55,000 applications when questioning an employee's termination in the financial year of 25-26. This was an increase of 25% on the year before, which itself was a record year. The Fair Work Commission's own analysis has also showed that in the year from February 24 to February 25, about 85% of employees questioned their termination of employment at the Fair Work Commission. Again, this was up from 76% the year prior, and they're predicting in this financial year that number is going to be over 90%. That's 9 out of 10 employees taking an application to the Fair Work Commission to question whether or not their termination was valid. And we're seeing it more and more, and this is a common theme we've heard from the others today. AI is in the background. Employees are being dismissed from employment, going home, jumping on their AI generator of choice, and within minutes producing a fully fledged application to the Fair Work Commission. And within an hour of their dismissal, they've lodged an application in the Commission. What this means for you is that you need to document your processes much more strictly. These employees are going to mediations with an inflated view of the prospects of their case, an inflated view of what their case is worth. The more documentation you can have that you can provide to the Commission, that the mediator can rely upon to talk to the employee in that mediation and convince them to come down off that ledge, the better chance you have of a favourable outcome early before having to go through the process of either defending it to a hearing at the Commission or a hearing at the courts. That is, of course, going to save you time, effort, and money. The secondary issue arising out of this increased litigation is that we are seeing a significant delay in the Fair Work Commission. What used to be a couple of weeks or a couple of days to receive an application is extending into 6 to 8 weeks. So you've dismissed an employee, they filed, but you're not receiving it for 8 weeks, and then you have to deal with it. And that delay has a flow-on effect to the mediation date, to the issuing of the certificate, and ultimately the hearing. General protections claims at the moment are taking 2 to 3 years to be heard at the court, and you'll be dealing with that in 3 years' time when you dismissed an employee. Slide, please, Dina. So the key point here is you need to document and show your workings more than ever as an employer. Of course, most employers aren't out there intending to break the law, but businesses change, the laws change, and you need to keep up with them to ensure that the reality is actually what is being projected to your employees and what they're seeing. Take worker classification, which I've already mentioned. Businesses, you're going to say that person's a contractor, and they may have started that way, but you need to ask yourself the question, what does a relationship actually look like? Do they operate their own business? Do they work for other clients? Who controls their hours and how is the work performed? The same applies to psychosocial hazards. Just saying we've got a policy to protect our employees is step one. And it's a great step one. You'll be beating half the employers out there if you have one. But can you actually show that you've identified the risks, you've consulted with staff, and you've responded to concerns, and then you've taken those practical steps to mitigate the risks in the workplace? Again, documentation is going to be key to defending any claims. Slide, please, Dina. So what should you be looking at now? I've put a range on that slide, a long list of things you need to be looking at. And of course, there's no order of importance. You can't look at them all at once. It would be impossible to do so. But as an example, you could start with your performance management and termination process. Make sure your managers know what the process is. Make sure they know what to document. Have a look at your contractor and casual agreements. Look beyond the label. Are they actually what you say they are or what you think they are? Or do we need to review how they're actually operating to make sure we've got their classification right? And then have a look at your policies. Not only should policies be updated, but employees have to be trained on them. Ask yourself after today's presentation, when was the last time I ran a sexual harassment or a bullying training session in my workplace? It's great to have a policy, but you have to do the training as well, and you have to document. Next slide, please, Dina. So that's my presentation, or my part of the presentation. So what have we seen from the others today? We've had Raynia asking if your commercial contracts and structures still reflect your business and how it operates. Louise has asked if you own and control the assets you rely upon. Evelyn has asked to check your leases to support your next move. Do they do what the business needs? Mark's asked if you've got any unresolved issues that are reducing your options moving forward. And I've emphasised the need for your workforce arrangements to keep pace with the way people are now working. You, of course, do not need to review everything at once, but you should identify where your documents, systems, or relationships may no longer match reality. The important point is not to wait until a sale, a dispute, or some other major event forces you to review your documents. Do it proactively and do it early. I'll now hand back to Raynia, who's going to start the fun part of this presentation, which is the case study, which will show how all 5 of our areas of law can sometimes end up being involved in one matter. Thanks, Raynia.
You're on mute, Raynia.
Sorry, couldn't get a mouse. All right, so yes, hopefully, as James has intimated, it is the fun part. As I mentioned at the outset, it is based on a real matter, and I know the client is on this webinar, but we have changed the name and we have embellished and actually compressed most of the facts, believe it or not. So what the case study involves is a successful chocolate retail franchise network that was trading as Chocovaro Chocolatier. The brand was owned by an overseas chocolate company, and our client had a license to use the name. That's not unusual in franchising. The network had been operating for years, had 18 franchise stores across Victoria and a loyal customer base. It sold premium chocolate products under this overseas brand that was well recognised. From the outside, the business looked healthy and everything was going well. The foundations, however, the business had been put in place many, many years ago. There was an exclusive supply contract and IP license, not a franchise agreement. The overseas chocolate company supplied most of the chocolate products and equipment to our client and also granted the right to use the Chocovaro name under that agreement. The store lease, all the store leases were connected to the Chocovaro brand. The business had never registered its own trademark. It didn't need to. It was licensing the Chocovaro name. So basically, to summarise, everything depended on one commercial relationship, one commercial agreement, the right to use someone else's brand and the ability to buy products and equipment from that supplier. The arrangement worked while the relationship worked. What then happened was the COVID-19 pandemic hit and interrupted overseas supply. Chocolate couldn't come into the country, nor could the equipment. The business had to keep 18 stores operating, and with the overseas supplier's consent, the business found a local supplier for chocolate and equipment and continued to carry on. There were emails between the parties confirming the new arrangements at the time, and everyone treated it as a practical response to an extraordinary situation. Unfortunately, however, there was no formal variation of that supply agreement. The overseas supplier was then sold. New owners came in. They had no history of the Australian business. They opened up the original supply agreement, which contained an exclusivity clause, and noted that no stock and equipment was being purchased by their Australian customer. And so they sought to enforce the agreement, the letter. The informal understanding that was in emails that kept the businesses running during COVID didn't give the client much comfort or certainty. The written contract still said what it had always said, which was it was an exclusive supply contract. Around the same time, the COVID experience had also made our client nervous and actually questioned what benefit it was getting from the overseas supplier, because they had now got used to sourcing chocolate and equipment locally. And all they were receiving was pretty much the use of a brand name. the business was concerned about the risks of having built its whole franchise network on an overseas brand that it didn't own and control. So around this time, they decided they needed their own brand. And I'll now hand over to Louise, who can talk you through what that involved, and it had its own complications.
Thanks, Raynia. So the client came to me and asked me to check out a name that they were actually particularly keen on. My initial searches of IP Australia's database didn't reveal anything, and it initially looked like a green light. But then in the same conversation, they told me they knew of a business in Bright in country Victoria that had the same name and was selling the same goods. And they said to me, "Do you think that matters?" And I said, "Yeah, I think it might." So I advised the client that the Bright business would probably have prior rights, which would trump our client's rights, even if our client managed to get a trademark registered. And I advised them strongly that they should choose another name. And to their credit, they accepted that advice. So a second name was chosen, Marvello Chocolate House. I conducted initial searches of the trademark, and the trademark application was filed, and IP Australia accepted it. So that was fantastic. At that point, we thought the name was secure. Then a Facebook page surfaced, which seemed to indicate an up and coming business that did not appear to be trading yet, which was using the same name. Unbeknown to me, the client contacted the owner of the Facebook page and had a conversation that went along the lines of, "You can't use that name because it's ours and we have an accepted trademark." But our client's trademark was in its 2-month opposition phase, when it can be opposed on particular grounds by anyone. So the Facebook people, who had previously been unaware of our client, then opposed our client's trademark, claiming that they had prior use. I quietly wished my client had not made that call. The evidence provided by the Facebook people was sketchy. And when I say sketchy, I mean it was a sketch, a logo that was very similar to our client's logo that was actually sketched out on a napkin on a date that they said they could prove was prior to the date of that our client's trademark application was filed. And they also claimed they had used the name itself in selling chocolates prior to us filing the Marvello trademark application. So right around that time, Raynia received a notice from the overseas supplier. Raynia, tell us what happened next.
All right. Well, it seemed that the overseas supplier discovered that our client was thinking about rebranding. And in response, they pretty much terminated the brand license, the whole supply agreement. And they gave us 7 days to stop using the Chocovaro name across 18 stores. So suddenly an IP strategy went from a rebrand or restructure to a business continuity issue. With the rights to use the Chocovaro name pulled from us, it was critical to secure rights to Marvello. So I pretty much raced into Louise's office to break the news to her. And Louise, you're probably better equipped to tell us what happened next.
So I was pretty keen to have the fight and go through the process of the opposition, but suddenly our client no longer had that kind of time, and it seemed was ending up in a different kind of fight. So the long and short was our client made a very swift commercial decision to pay the Facebook people to purchase the rights of the trademark. For them, it was worth paying quite a bit of money to people whose evidence was pretty sketchy at best in order to ensure they could move ahead with the rebrand of their business to Marvello. So Raynia, now that the client had secured the rights to the Marvello trademark, what happened next?
Well, we had 7 days to organise new signage, packaging, websites, social media, customer communications and material for an entire franchise network. The good news for the network was that its franchise agreement was well drafted and contemplated a rebrand, so the business could continue to operate under a different name, but not without some cost. So the franchisor, the client, made a decision to fund the rebrand, and it did so for 16 franchisees. Unfortunately, that's not where the story ends. The stores operated from physical premises, so replacing the name above the door created other issues. So I had to walk into Evelyn's office and have a chat to her. So, Evelyn, do you want to chat to us about what happened?
Yes. So, of course, everyone was so busy focusing on the urgency of the rebrand, they forgot, hang on a minute, there's 18 leases that we have to deal with, and 18 landlords that we have to deal with, and 18 different permitted uses that we have to deal with. So a lot of the leases that had been entered into, and this sort of ties back to my points before, were specifically tied to the Chocolavaro chocolatier store brand. So that meant that they couldn't just stick a sign up on top of the premises and that was the end of it. They had to actually go and seek the landlord's consent. Now, trying to urgently coordinate seeking landlord's consent in the time frame that, Raynia and Louise were presented with proved really difficult, because it's one thing to be able to, go to one landlord, but to go to 18 with 18 different leases and 18 different permitted uses and 18 different consents proved to be quite difficult and challenging. Some landlords were sympathetic, some landlords were quite helpful, some landlords provide their consent. Others wanted more detail, they wanted to know more about what was going on, more context, they were relying on the strict provisions in their leases. And the other problem was not all of these leases were for the same terms, as well, as you can appreciate as well, they're all for different terms. But it also meant that the signs that everyone was trying to put up so quickly were kind of in limbo land. They couldn't really go up, because if you put those signs up, that's actually a breach of the lease for changing the permitted use. So there were so many things that had to be juggled. In the end, 16 of the 18 landlords consented, and they agreed to allow the signage to change to Marvello. But of course, 2 didn't. Why would it be that easy as if you get all 18 over the line in such a short period of time? So I'll hand over to Mark now, who then had to get involved to work out what to do with the 2 that didn't agree.
Evelyn, thank you for that. And those keeping score, Raynia also walked into my office in relation to the topic of this next stage, which was a dispute stage. So as Evelyn has beautifully captured, there were 2 holdouts, and this is where the rubber hit the road with those 2. Marvello, realising that they were not for turning, issued breach notices quite appropriately under the franchise agreement. In response, the 2 holdouts, very interestingly, in conjunction with the overseas licensor, began proceedings seeking injunctive relief against our client in a Supreme Court. Now, that application was a laundry list of claims. It sought to restrain our client from acting on the breach notices. It sought a whole bunch of related restraints. It bizarrely sought an account of profits, despite the fact that we were at an interlocutory stage. And it treated itself as a discovery application. So there were also voluminous requests for documents and records. There was one slight problem, though, that those parties faced, which was that their affidavit material went nowhere near far enough in terms of being responsive to the relief that they were seeking. So that was a good start for us, and we realised we had an opportunity to sort of build from there. Hearing dates were listed fairly urgently. The client, to its great credit, decided to properly resource the matter. So a team, and you've heard from multiple people now, we work together as a group, but a team within MST were assembled and barristers were appointed, including a King's Counsel. The injunction proceeding was defended interstate by us. Comprehensive affidavit material was put on. One of the themes that we've been going through today has been the value of retaining evidence and taking steps early. All of the work that had been done, including the work regarding the breach notices, came right to the front. It was all available. It could all go into the affidavit, and it demonstrated a pattern of behaviour on behalf of our client, which was very reasonable, despite the tricky circumstances that the client found itself in. I'm really pleased to say that the 2 holdouts and the overseas licensor failed spectacularly. Not only did they not get a single order that they were seeking, costs orders were also made against the 2 holdouts. And I can tell you that His Honour went 9/10 the journey towards making a costs order against the solicitors acting for those parties. Now, as many of us know, that's an extremely rare order to get. So the fact that that order was even being considered was, 1, a reflection of their preparation, but 2, a reflection of ours. So it was especially satisfying to get that result for the client. The lesson from my perspective, or my part of the tale, the steps taken prior to the proceeding really helped with preparation. Marvelo had done all the right things in terms of getting advice, issuing notices, and then acting on strategy. That laid the foundation for success in court. I'll now pass to James, who will enlighten us in relation to some of the employment matters that the client faced. Thank you.
Thank you, Mark. Whilst this was all going on in the background, there were employees who were dealing with questions from suppliers and customers, some of whom were becoming quite aggressive. The employees had no control over the legal dispute, but they were the ones at the coalface facing these problems. There was also a great deal of uncertainty for them. They didn't know if they'd have a job the next day. So what began as a contractual and branding problem was now affecting the employees. Management was, of course, focused on keeping the stores open and completing the rebrand, but cracks were starting to show in the employees. So to avoid the likelihood of employees raising claims, we were able to assist Marvelo by running training sessions with store managers, who in turn consulted with their staff about their concerns. We then implemented a number of policies to ensure that employees were provided the safe system of work that they were entitled to during this period and after. Additionally, unbeknownst to us, Marvelo had run out and engaged a number of individuals, next slide please, Dina, individuals to operate as delivery drivers, calling them contractors. This had the initial benefit of reducing onboarding delays to make sure the stores were kept supplied, but those arrangements were only meant to be temporary. But it worked, as often is the case. So the people who had initially been engaged in short-term support were now working regular hours and performing ongoing roles. This, of course, exposed Marvelo to claims for underpayment and misclassification. We assisted Marvelo in reviewing each of those relationships individually, determining whether the individuals were better classified as employees or truly were contractors, and then implementing the relevant agreements to avoid any future litigation. I'll now hand back to Raynia, who'll close out the case study.
Thanks, James. So what we saw is the original problem began with an old supply agreement and a brand, the business didn't own. It quickly spread into a trademark issue, 18 lease dispute, franchise dispute, and ultimately court proceedings. And also a question mark over how the business managed its own people. Whilst the client wasn't the author of the original supply agreement and was clever in anticipating a possible brand or rebrand by building that into its franchise agreement, the fact remains that it got embroiled into a supply chain dispute arising from a poorly drafted agreement. That in turn absorbed significant management time, legal cost, and attention across the whole network. So why did we tell you the story? Well, the point of telling you is whilst our client did a lot of things right, it ended up being dragged into something it didn't want to be dragged into. We were fortunate. We were, as a firm, we were able to be involved in each layer of the dispute, and fortunate enough to have the expertise to be able to deal with all the twists and turns that make up the story. If there's any takeout, it's that it didn't start as a legal crisis. It started with a legal contract that had been made years earlier that sat in a bottom drawer but didn't keep pace with changes that had come about either to the supplier or to the client. And those risks stayed quiet pretty much until they didn't and something went wrong. So I think we're probably running a little bit over time, and I had promised in the beginning that we would have questions or time for questions. I've had a quick look. I think there is only one question, which I believe, James, is for you. Do you want me to
I'll
read?
take that one.
Yeah, do you want to take that one?
Absolutely. Thank you, Sonia, for your question. The question is, does a clause within an employee contract around working from home stating the business does not offer this as part of the specific role cover an employer? Unfortunately not, Sonia. Both under the Fair Work Act and the proposed Victorian legislation, contractual clauses don't come into whether or not an employee is entitled to it. The Victorian legislation as drafted is it's going to be a right for the employees to have 2 days at home. And being a legislative right, it will overcome any contractual obligations they've got to you as an employer. You will be able to question it based on whether or not there's going to be a significant effect on the business or the ability for the employee to do their job. Take, for example, a junior. If they need supervision and training on an ongoing basis that can't be adequately provided with them working at home, then yes, you could argue that they need to be in the office, but there's not going to be a carte blanche ability for us to say no because there's a contractual term. We'll have to assess the reasons why we can refuse on a case-by-case basis.
All right. Thanks, James. I don't think there are any other questions, but we'll have another look, and we're proposing to circulate these slides so we can certainly provide answers to any other questions. I'll close off by thanking everyone for joining us today. We hope the main takeaway from today's seminar is, or webinars, to look for legal issues early, seek advice each time there's a change in your business, because we can see the consequences and the problems that arise if your documents and your foundations don't keep up with those changes. And just remember, the best time to review and audit your business is when things are good and calm and the relationship is good. You really can't plug the holes or gaps when you're in the middle of a dispute or a sale. So thank you again, everyone. Enjoy the rest of your afternoon.
Thanks, everyone.
Thank you.
Thank you all.